Racing, Parimutuel Wagering, and Breeding Law, Section 102 provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor, by and with the advice and consent of the Senate. 4 members confirmed by the New York State Senate are necessary to afford the commission an ability to undertake or establish a quorum and undertake action. They may want to mute. This present order or meeting of the commission is now called to order. Ms. Buckley, will you please call the roll?
John Crotty.
Here.
Peter Machete.
Here.
John Baklemba. Barry Sample.
Here.
Jerry Skurnick.
Here.
Todd Snyder.
Ms. Secretary, please have the record reflect that a quorum of qualified members is present, thus enabling the transaction of business. Mr. Baklemba is a little under the weather, and Mr. Snyder had a previous commitment.
Minutes of the commission meeting conducted on October 28th, 2019 have been provided to the members in advance. At this time, I'd like to ask members if there are any edits, corrections, or amendments. Hearing none, may I have a motion to approve?
So moved.
Second?
Second.
All in favor?
Aye.
Next item on the agenda is rulemaking. New York State Racing, Parimutuel Wagering, and Breeding Law 104.19 authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibilities. In that regard, the Commission will from time to time promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. Today, we have 4 items for consideration. Rob, will you please start?
Certainly. For commission consideration is the adoption of a consensus package that included the deletion of an obsolete, erroneous, and redundant statement about the maximum weight of safety vests at thoroughbred racetracks from Commission Rule 4033.3, and to propose to add the term racetrack operator to the definitions in Commission Rule 4000.3 for thoroughbred racing and 4100.1 for standardbred racing, so that the term may be used for convenience throughout other thoroughbred and standardbred rules. A notice of the proposed rules was published in the State Register on October 2nd and October 16th, meaning that the latest public comment period closed on December 15th. No public comments were received. Staff recommends that the Commission adopt each rule, but for purposes of clarity, I suggest the Commission consider each proposal independently.
In your package, everyone had received a rulemaking component of the package and suggested that we take each of the rules individually. Are there any questions on the rules in the package at all? No? May I have a motion to adopt the first rule proposal to add the term racetrack operator to terms defined in thoroughbred racing rules? May I have a motion?
So moved.
Second?
Second.
Any discussion of the motion? All in favor?
Aye.
Any opposed? Motion carries. Second item, may I have a motion to adopt the second rule proposal to remove obsolete reference to safety vest weights? May I have a motion, please?
So moved.
Second?
Second.
Any discussion of the motion? All in favor?
Aye.
Any
Aye.
opposed? Motion carries. The third item is, may I have a motion to adopt the third rule proposal to add the term racetrack operator to terms defined in standardbred rules? May I have a motion, please?
So moved.
Second?
Second.
Any discussion of the
The
motion?
record reflect I was second, please.
Got it. First. You're first and second.
Oh, the first and second.
Seconded by Commissioner Crotty. Any discussion of the motion? All in favor?
Aye.
Any opposed? May I have a vote? Motion carries. Rob, will you please outline the next item?
As for Commission consideration is a proposal to amend Rule 4024.1B1 to broaden the requirement of a lip tattoo for a thoroughbred horse to race in New York to include digital tattoos. The amendment will conform Commission rules with the nationwide digital tattoo system, which was introduced by the Jockey Club to first apply to horses that will be 2 years old in 2020. No change to the Commission's harness racing rule is necessary, as it is presently broad enough to permit any tattoo, whether lip or digital. As the Jockey Club has required a digital tattoo to register all thoroughbred foals since January 2018, staff believes this proposal can advance as a consensus rulemaking, as it makes a technical change and is not controversial. Staff recommends that the Commission authorize the proposal as a consensus rulemaking.
May we have a motion to propose a rule amendment regarding thoroughbred digital tattooing?
So moved.
Any second?
Second.
Discussion of the motion? Hearing none, all in favor?
Aye.
Any opposed? Motion carries. The next item on our agenda is adjudication. Rob, will you please outline the first of the two cases?
Certainly. On July 19th, 2019, the Bureau of Licensing denied the application of Carl Pangiolesi Jr. for a gaming employee registration to work as a dealer at the Resorts World Casino in Catskills. The denial cited New York Racing Parimutuel Wagering and Breeding Law, Section 1318.1C, which provides in relevant part that the applicant must prove qualification by clear and convincing evidence, and for disqualification on the grounds of the conviction of an applicant of any offense in any jurisdiction which is or would be a felony or crime involving public integrity, embezzlement, theft, fraud, or perjury. The hearing notice also cited Racing Law Section 1318.1F, which provides disqualification on the grounds of any other offense under present state or federal law, which indicates that the licensure of the applicant would be inimical to the policy of this article, provided, however, that the disqualification provisions of this section shall not apply with any regard to a misdemeanor conviction. Mr. Kingliosi requested a hearing, which was conducted on September 13th. The hearing officer submitted a report to the Commission Secretary dated October 23rd, recommending that the registration denial be sustained. The Commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The Commission duly deliberated and considered this matter and determined upon a 4-0 vote to sustain the hearing officer's report and recommendations. Next case, please.
The state steward for the NYRA racetracks issued a series of 4 rulings on December 6th and 7th, 2018, suspending trainer Eduardo E. Jones for a total of 60 days and fining him a total of $5,000 for acting as a front trainer of the horse Tanya's Gem in 3 races conducted at Belmont Park in September and October of 2018, and 1 race at Aqueduct Racetrack that was to be conducted in November of 2018. Each in violation of Commission Rules 4007.5, 4022.17, 4025.5, and 4042.1D, and 4042.1F. The state steward disqualified and unplaced the horse in each of the 3 Belmont Park races and scratched the horse before the Aqueduct race was contested. The cited rules provide as follows. 4007.5, no horse shall be qualified to start in any race unless entered by a licensed owner and in the charge of a licensed trainer. 4022.17, no horse that is disqualified or ineligible as provided in this subchapter or nominated by or the property, wholly or in part, of a person who is unlicensed, disqualified, or ineligible, as provided in the subchapter, may be entered or started in a race. 4025.5 provides any horse that has been the subject of an improper practice may be disqualified for such time and for such races as the steward shall determine. 4042.1 reads, any person found by the stewards to have violated any of the following subdivisions of this section shall have punishment imposed upon him or her, and the stewards shall take such other action in the manner as the stewards may deem proper under this article, including reference to the Commission. D, enter disqualified horse if a person willfully enters or causes or permits to be entered or to start in any race a horse that such person knows or has reason to believe to be disqualified. And F, a fraudulent corrupt act, if any person be guilty of any improper, corrupt, or fraudulent act or practice in relation to racing, or shall conspire with any other person to commit or shall assist in the commission of such act or practice. Mr. Jones requested a hearing, which was conducted over 4 days in March and April of 2019. The hearing officer submitted a report on November 14th, finding the violations unfounded and recommending that the suspensions and the fines be overturned, that the placement and the purse earnings of Tanya's Gem and the 3 Belmont Park races be restored, and the disqualification from the Aqueduct race be upheld. The Commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The Commission duly deliberated and considered this matter and determined upon the 4-0 vote to sustain the hearing officer's report and recommendations. That concludes our adjudications for the day. The next section that we must consider today are updates to existing Commission operational resolutions. Rob?
Sure. At the initial meeting of the Commission following the seating of members, the Commissioners adopted a variety of resolutions governing operations. These resolutions included a plan of organization, an administrative plan, and various delegations of authority. Since those initial resolutions were adopted on June 26, 2013, the Commission has increased responsibility over additional forms of regulated activity, including commercial casino gambling and interactive fantasy sports. These new resolutions would simply amend those existing resolutions to reflect these changes.
We have a series of amendments that we need to consider today. Rob, could you please outline the first of those amendments?
Certainly. The first is a proposed amendment to the plan of organization, which would recognize both that the New York State Constitution was amended to permit casino gambling and that the New York Racing Parimutuel Wagering and Breeding Law charged the Commission with the regulation and oversight of commercial casino gambling, and that the Commission was also subsequently charged with the regulation and oversight of interactive fantasy sports.
Commissioners, any questions on the proposed resolution plan for organization? May I have a motion on resolution 1-2019?
So moved.
Second,
Second. Good motion.
any discussion?
None.
All in favor?
Aye.
Any opposed? Motion carries. Rob, would you please outline the second proposed amendment?
Certainly. The second proposed amendment is to the plan of administration, which recognizes that administration of the agency may be undertaken by the executive director or, in their absence, by an acting executive director.
Commissioners, any question on proposed resolution 2-2019, plan of administration?
Who determines that? Do you name the acting deputy, like when you're not around, or it's in the instance?
I delegated authority when I left last time
Okay.
of my operation.
And that's like a formal thing you do?
Correct.
Yeah,
And
okay.
it was filed with the Secretary of State.
Oh, wow, okay.
And that, at that time, that made Ron the acting
That is correct.
administrator.
Right.
Okay?
I didn't know there was a whole process, but makes sense that there would be.
And it's similar to what you would do for an agency, it's an agency commissioner, when you have an acting
Right,
person.
but yeah, but that stuff, I guess, is already sort of built in.
Correct.
Yeah.
May I have a motion to adopt resolution 2-2019?
Yes, so moved.
Second,
Second.
discussion of the motion?
Concluded.
All in favor?
Aye.
Any opposed? Motion carries. Rob, would you please outline the third proposed amendment?
The proposed amendment to the delegation of authority would, like the first resolution we considered, recognize both that the New York State Constitution was amended to permit casino gambling and that the Racing Parimutuel Wagering and Breeding Law charged the Commission with the regulation and oversight of commercial casino gambling, and that the Commission was subsequently also charged with the regulation and oversight of interactive fantasy sports. This proposed resolution would explicitly recognize such and include specific language regarding the delegation of certain matters in regard to the regulation of commercial casinos and interactive fantasy sports.
Commissioners, any questions on proposed resolution 3-2019, delegation of authority amendment? Hearing no discussion, may I have a motion?
So moved.
Second,
Second.
all in favor?
Aye.
Motion carries. I think that concludes your series of amendments for today. Okay. There any old business anyone would like to raise? Hearing no items, we move on to new business, which almost dovetails with some old business. We need to, or would like to, revisit the issue of the usage of the crop. While we have last week, California Horse Racing Board voted to propose a stringent limitation on the use of the riding crop. Under the California proposal, a horse cannot be struck more than 2 consecutive times without having the horse a second chance to respond, and the crop cannot be used more than 6 times during the entirety of a race. In addition, jockeys must use the crop in an underhand position, and the crop cannot be raised above the shoulder. I am also aware that the Jockey Guild is adamantly opposed to the elimination of the use of the riding crop, but for safety purposes, as they believe such an action would have serious consequences and could result in an even greater risk and danger for jockeys and their horses. They did express some concerns with the California proposal. I recollect, or we all recall, that in late 2015, we had several people from the Jockeys Guild attend a commission meeting in which they discussed changes to the use of the crop rule that were being considered. Given that the jockey colony is within probably about 10 miles, 10 minutes from where we are now, I would like to have staff discuss with the colony the changes proposed by the California, as well as discussing California's proposal with other leading regulatory jurisdictions, and report back at a future commission meeting. Hopefully we can do this at a January or February meeting at the latest. Does everyone comfortable with having them look at the issue and report back to us?
Yes.
And if we could have staff do that, that would be very beneficial and useful in providing us some guidance. Does anyone have any other new business?
I think it's worth noting,
Yes.
the commission, that, you know, what happened in California and the rules, many of the rules proposed, and this was outcrop of some of that. Also, you know, the tracks announced a sort of multi-jurisdictional new set of standards they were going to impose on themselves in terms of trying to strengthen horse safety among them. One of them they did not propose as part of the package that I saw, and again, it could be wrong, had to deal with the use of Lasix, race day Lasix. So I did not see it in their proposal. That's not to say it was out there. I tried looking for an answer. I didn't see it in there, but the New York State and NYRA had said that they were looking to impose those standards on themselves in terms of the administration of Lasix. We spoke briefly off the record with the gentleman running the track now, Mr. O'Rourke. They said they were pretty committed to doing that, and what happened is Kentucky Horse Commission, Gaming Commission, whatever they're called over there, has proposed and enacted a series of rules that are waiting for the governor's signature. I don't know where the California status is, but it's out there. We think I think that's a great step in the right direction, and it's something that, you know, we should sort of see how it plays out and what would make sense from a regulatory point of view for us. It's too early to move.
Yeah, take into account what you said. What might be useful for our January meeting, and it is also very timely, is that NYRA says that they're going to initiate the modifications in the use of Lasix in January. So if we can have staff report back to us at our next meeting to see where things are on that. And then we could revisit and review what's going on, and then maybe reconsider our current position on things.
For sure, and we should take a look at, I haven't seen the rules, I don't know if staff has either, but Kentucky did pass something, as did it pass the California Gaming?
It's proposed.
It's proposed. I haven't seen them, so
Okay.
it might be worth taking a look at it in the context of
So
that.
maybe we can, under the rubric of a LASIX update, we look at what NYRA's doing,
Sure.
where they have implemented, what are some of the, at least the first sniff results that they're getting from that?
I don't think
Sniff
the
results from use of LASIK.
Results won't come till March, I think.
Well,
But
at
in
least,
terms of
when I talk about
implementation
results, I'm
rules,
not
yeah.
talking about consequences on the
Okay.
animal, I'm talking about, are they doing anything?
Right,
You know,
right.
have they been, you know,
What does
and
it
how they're going about doing it? Because when we met with NYRA, we had a few questions. What they're doing, how they're gonna do it, and when they're gonna do it, you know?
Right.
So if they can report back on what they've done, how they've done it, and when did they do it, in
Right.
terms of meeting the timetable that they laid out for us. And at the same time, report back on where the other states are with their proposals. So if we can have a LASIX discussion at our next meeting. It would be more of a form of an update. It'd give us some guidance on
Yeah.
whether we do or do not need to take some action in the short term. Is that fair enough?
Fair.
Reasonable enough?
Perfect,
Okay.
yeah.
We'll do so.
Okay, that concludes the published agenda for the day. Our next meeting would have been next week, so we're doing what are we doing, November and December today, I guess. Our next scheduled meeting would have been January 27th, but Kristen, if you can try to coordinate where everybody is on, for our next meeting date for next month, and what we have to do substantively on whether we merge January and February, or we can do January. But I think we've carved out a few things today that makes it clear that we should be meeting on January. So it's really just the logistics around that. So it's the end of the year.
Happy
Happy
New Year.
Merry
holidays.
Christmas, happy holiday. And I think this is the first meeting in probably the last 3, at least, meetings where we haven't had a death notice of some type, you know?
good.
So at least we're not ending the year on a sour note. All right, thank you, and everybody have a good holiday.
Thank
Can I have a motion to adjourn?
So moved.
Second? Okay, all in favor? Machete wants to stay, because you don't want to have to spend any more holiday money. Thank you.